Hi, everybody, and welcome to this another webinar organized by the African Arbitration Association, an association which purpose is to promote arbitration and ADR as a whole in Africa. My name is Gaston Kenfak Douachny. I am currently the Director of Legislation at the Ministry of Justice in Cameroon, here in Yaoundé. And I'm also the Vice President of the African Arbitration Association. Our guest of today is our friend, our best friend, Mohamed Oussama. But before introducing him, let me thank Dr. Rukia Baruti, the Secretary General of the African Arbitration Association, whose availability and effort has made it possible for us to be here today. And I wish also to thank all the attendees for their presence. That said, let me now introduce our friend Mohamed Oussama. He's a former judge, a practicing lawyer in Egypt, and sits as an arbitrator in domestic and international arbitration. He is admitted to the Egyptian bar at the appeal leave. He has more than 10 years of practice focused on arbitration and litigation. He served as a judge at the Egyptian Council of State for about 7 years before joining the bar. He is currently representing clients before different fora, domestic litigation, international commercial arbitration, as well as investor-state arbitrations. Mr. Oussama also has numerous publications focusing on issues of Egyptian law, international law, and investment arbitration. We can leave it like that for now, because if we have to say more, we'll spend the whole 1 hour we have just to introduce Oussama. That I prefer that we leave it like that for now. But during 40 to 45 minutes, Mohamed will have to talk about challenging the validity of award rendered in investment arbitration from the Egyptian perspective. So, my friend, you have the floor. 40 to 45 minutes.
Thank you very much, Gaston, and thank you for the very generous introduction. I'm lucky to be here with you today, and I would like to first start with thanking the African Arbitration Association for all of its efforts in organizing such a marvelous event. And I've seen the previous webinars that took place in this webinar series and how relevant the topics that speakers focused on. And personally, I found it very enriching in terms of arbitration, generally, whether international, commercial, or investment arbitration. And it actually provided me with very important information on how arbitration is conducted in many different jurisdictions in Africa and overall worldwide. So I thank the African Arbitration Association, and I thank you, Gaston, for making the time and for our discussions prior to today's webinar, which I found very useful. So thank you for that, and I thank the attendees.
My pleasure.
Yeah, thank you so much. And I thank all the attendees for making the time to attend today. And I look forward to the Q&A section, as I don't like to hear myself talk for a long time, but I'll do my best to keep it interesting and entertaining. Before delving into the substance and the topic of today's webinar, which is providing and talking about the Egyptian court's perspective when it comes to the review of arbitral awards rendered in investment arbitration. I would like us to take a step back a bit and tackle the relevance and importance of this topic. Because I believe, there's no merit to discussing anything unless we, know why is it important and why are we talking about it. So if we start to tackle the relevance of the topic, obviously what comes to mind to me, and I think to Gaston and the attendees, is that arbitration is not cheap. It is relatively expensive. And for interested parties, to invest in arbitration proceedings, and at the end of the day, after a couple of years of participating in the proceedings and finally getting a favorable award, they find out that they still have a journey to take, in order to enforce that award. Because, basically in international commercial arbitration, awards are just, a piece of, informal document that needs to be recognized and enforced in the relevant jurisdiction in order for the, the party who got the award in his favor to be able to get something out of it. So that's one in terms of relevance. The second point is that, when we, as lawyers, advise clients on, whether or not to proceed with investment arbitration proceedings, we always tell them, you need to look it's better and prudent not to just look, in front of us only, but to look ahead and to see what kind of jurisdictions would be relevant in the future and what types of applicable laws would come into play in order for you to be able to proceed with enforcing a favorable award. So it's a matter that is highly complicated, I would say, and it involves many jurisdictions. And for that reason, it is not surprising, to see in our world today that practitioners often seek the assistance of counsel in the relevant jurisdictions in order to provide them with valuable input on how, a potential favorable award could be recognized and enforced in their respective jurisdictions. So in terms of relevance, I think we've covered that. Before I intend today to discuss with you a very important ruling rendered by the Cairo Court of Appeal in June 2020. But before we do that, I would like to briefly discuss why investment arbitration is special and what kind of special rules apply to it, so that when we proceed to tackling the Cairo Court of Appeals ruling, we get a sense of what is relevant and why these issues are important to tackle, and to be able to comment on the substance of the Cairo Court of Appeals ruling. So if we look at investment arbitration, the first thing that distinguishes it from international commercial arbitration is that the parties are different. Why? Because in investment arbitration, we have a state, the host state of the investment, as a party to that proceedings. Theoretically, you can find the host state as a claimant or as a respondent. But usually in practice, we've seen host states, as respondents, fighting claims pursued by foreign investors. So that's one in terms of the parties. If we consider the applicable law, and in terms of the applicable law, we always aim to distinguish between the merits of the dispute and the rules that apply to the arbitration proceedings themselves. So regarding the applicable law to the merits, in order to determine that, tribunals, investment tribunals need to look at the relevant international investment agreement in case there is a provision, that says X law shall apply. If not, it goes to basically the agreement to arbitrate and see if the parties have made an explicit agreement as to which law shall apply to the underlying dispute. And at the same time, what's interesting is that international law is always there. So if parties to an investment arbitration agree to the application, for example, of Egyptian law to their underlying dispute, international law would still be relevant. It would still be looked at and considered by investment tribunals. And investment tribunals would need to see if there is any sort of contradiction between international law and the law chosen by the parties, the domestic law chosen by the parties, in order to decide on any issues, that are contradictory between the two sets of law. If we move on to the applicable law to the proceedings themselves, it is very important to distinguish between ICSID investment arbitrations and non-ICSID investment arbitrations. With respect to ICSID, it has a unique stance, and that unique stance is derived from the fact that arbitration proceedings conducted under the ICSID are delocalized. And by that we mean that there is no, legally speaking, there's no seat, there's no place of arbitration. And this is very interesting. It was interesting to me back in 2009 when I first, started working in this field, and it remains interesting to me now, to consider that, arbitration proceedings under the ICSID are considered, to be happening in space. They don't have a jurisdiction. So that's important to note with respect to ICSID investment arbitrations. So, saying that, the applicable law to proceedings when ICSID arbitrations are involved, we go to the ICSID Convention and the ICSID arbitration rules. Moving on to non-ICSID arbitrations, and these are in the realm of investment arbitration, these are ad hoc arbitrations. So these can be conducted under the auspices, not under the auspices, but under the supervision of an appointing authority. So, for example, we see lots of investment arbitrations taking place with the PCA, the Permanent Court of Arbitration, being the appointing authority. So there are many examples of that. So another issue that is relevant in terms of distinction is the issue of the seat and venue. And I believe we've already briefly, discussed the issue of the seat when ICSID arbitrations are involved. But in terms of non-ICSID arbitrations, these do have a seat, and hence the importance to agree on such a seat at the beginning of the proceedings in order to be able to keep an eye on any mandatory provisions in the relevant applicable arbitration law in the seat of arbitration, in order to avoid any instance where the award rendered at the final stages of the investment arbitration, to be subject or compromised to review and, to being nullified by the competent court in the country of the seat. And the final point here is the issue of recognition and enforcement. And again, it's important to differentiate between ICSID and non-ICSID proceedings when it comes to this point, because under the ICSID Convention, it again has a unique stance, because if we go to the ICSID Convention and review it, we will find that member states to that convention, states that signed and ratified the ICSID Convention, have committed under the ICSID Convention to recognize and enforce any arbitral awards rendered by ICSID tribunals in their own jurisdictions. So that's very important. It provides a unique benefit to parties once who get the favorable award. The ICSID award is recognized and enforced by the member state to the ICSID Convention that the party seeks to enforce the award before. With respect to non-ICSID arbitration, the situation is less beneficial to the party that won the arbitration, because again, there's no automatic enforcement, and the party needs to apply to the competent court in the relevant jurisdiction, and seek to have the award recognized and enforced. And as we see in practice, the quantum involved in investment arbitrations is huge, and is very huge compared to other types of arbitration. And hence, we see in practice that, the losing party does not really, it's not easy for them, to accept the award and to enforce. So they seek to challenge the award, and at the same time, settlement negotiations might take place in order to have the award amicably enforced. So that's that for the intro, the issues that I wanted to tackle before we proceed to to discussing the Cairo Court of Appeals ruling. By way of a background, before we delve into the finding and reasoning adopted by the Cairo Court of Appeal, I have to say that this dispute, involves an investment arbitration that took place between the Libyan government and a Kuwaiti investor. And although the ruling is publicly available, I'm not gonna name names. And I think Gaston would agree with me on that. So the dispute involved.
Because you need the agreement of the party to do that.
Exactly, Gaston. So yeah, again, the dispute involved the Libyan. Sorry, yeah. So
it's okay.
Yeah, we have the Libyan government and we have a Kuwaiti investor, and the contractual relationship between the two parties started in 2006. Where an investment contract was concluded between the two parties, under which contract the Libyan government was to provide the Kuwaiti investor with a piece of land free from any obstacles in order for the investor to be able to implement its investment project. And the duration of the contract was to last for 90 years. And that's, I would say, common in terms of investment contracts. And this is, I think, due to the fact that investors need to put in a lot of cash, a lot of investment, and it takes time for them to be able to start realizing profits. So one of the negotiating points that we see in practice is that investors tend to highlight this point, and it becomes one of the non-negotiable points during the negotiation phase. So we have the 2006 contract. We come to implementation of such a contract. Unfortunately, years passed by. The Libyan government, according to what is provided in the ruling, did not perform its contractual obligation, and amicable attempts were made by the investor to amicably settle the dispute. Unfortunately, such attempts did not succeed, and therefore the investor opted to initiate arbitration proceedings under the relevant international investment agreement, and that is the Unified Agreement for the Investment of Arab Capital in Arab States of 1980. It's a long name, so I will be referring to the Unified Agreement in my talk as the treaty. So arbitration proceedings began, the tribunal was composed, and an award was issued in favor of the Kuwaiti investor in 2013. So the tribunal, by a majority vote, decided, that the investor is owed compensation due to the breach by the Libyan government of its obligations under the treaty. And the tribunal decided to award the investor compensation of about US dollars 936 million. As you can see, this is a substantial award, and therefore it's not surprising that the Libyan government sought to have the award nullified before Egyptian courts. But I think at this stage, some of you would ask, why is Egypt even involved in such a case? And that's a very relevant question. So we have a Libyan government, we have a foreign Kuwaiti investor. Why Egypt? The answer to this question goes back to the fact that the parties, after the initiation of the proceedings, and before the when tribunals conduct case management conferences, and in preparation for issuing a procedural order and the terms of reference, the parties agreed to apply the arbitration rules of the Cairo Regional Center of International Commercial Arbitration, as issued in March 2011. And the parties also agreed, and I quote, from the ruling that the hearings will take place, if any, in Cairo, Egypt. So we have two things, an agreement to the application of the Cairo Regional Center's arbitration rules, and we have the agreement to conduct hearings, if any, in the Egyptian capital, Cairo. After the award was issued in favor of the Kuwaiti investor in 2013, the Libyan government proceeded with filing a nullity action before the Cairo Court of Appeal in 2014. And to those who are not familiar with the Egyptian jurisdiction, Cairo Court of Appeal is the second level or degree court. And the reason why the nullity action was filed before the Cairo Court of Appeal is that under the Egyptian Arbitration Law, if you're dealing with a non-domestic arbitration, you go to the Cairo Court of Appeal in case of filing a nullity action. And unless the parties have agreed to the jurisdiction of another appeals court within Egypt. So that's the reason why the nullity action was filed and accepted before the Cairo Court of Appeal. So we have the nullity action filed. It's worth noting that two rulings by the Cairo Court of Appeal were issued in 2014 and in this case. The first one in 2014, in it, the Cairo Court of Appeal decided that the nullity action was inadmissible. And the reason for that is because the Egyptian Arbitration Law does not apply to these proceedings because these are investment arbitration proceedings that were not seated in Cairo, Egypt, and therefore the Egyptian Arbitration Law, along with its provisions governing the review of awards, do not apply to this investment award. So that's the decision of the Cairo Court of Appeal of 2014. The Libyan government did not accept it. It proceeded with challenging it by way of cassation. And the Court of Cassation, which is the highest level court in Egypt, decided to cancel that ruling. It did not agree with the Cairo Courts of Appeal reasoning and decided to refer the case back to the Cairo Court of Appeal for another ruling on the merits. What's interesting is that when the case got back to the Cairo Court of Appeal for the second time, the Cairo Court of Appeal issued another ruling in 2018 finding non-competence. And again, it's another form of saying Egyptian courts do not have anything to do with this ruling. It's an investment arbitration award, and we're not competent to hear anything concerning it, given that Egyptian arbitration law does not apply to it. Again, the Cairo Court of Cassation, when the case was referred to it, as the Libyan government challenged the second ruling of the Cairo Court of Appeal, the Court of Cassation canceled the second ruling by the Court of Appeal and returned the case again to the appeals court for a third ruling on the merits. And now we arrive at the at our destination. The Cairo Court of Appeal on the 3rd of June 2020 issued a decision on this case, accepting the nullity action, and on the merits deciding to nullify the arbitral award. And we will come and discuss why the Cairo Court of Appeal decided to nullify it. So there are two things that, given this background, I would like to discuss with you today, and I look forward to your questions when we come to the Q&A section. The first issue is a nullity action of an arbitration award rendered pursuant to the treaty, which is the Unified Agreement concerning the investment of Arab capital in Arab states, is it admissible under Egyptian law? And before we, tackle the relevant provisions of the Egyptian arbitration law, which are relevant and apply in answering this question, it is important to note that international agreements in Egypt, once signed and ratified by the Egyptian state, they are considered part of the domestic legal system in Egypt. Not only that, they come at a place that is higher than domestic legislation. So that's very important to note, and it's exactly why it is important to first look at the provisions of the treaty itself in order to try and find an answer to our question. And in fact, the Egyptian arbitration law itself, in its Article 1, confirms this point. And it starts, the provision of Article 1 starts by saying, without prejudice to the provisions of international treaties that are enforceable in the Arab Republic of Egypt, the present law applies to, and it proceeds to determine the scope of the law's application. So again, this is not an unusual provision. It's fully in compliance with the Egyptian constitution and the hierarchy and place that international law takes once it becomes part of the domestic legal regime in Egypt. So we now know that the treaty prevails over domestic law in Egypt. So when we look at the provisions of the treaty, we see that Article 2, Paragraph 8 of the treaty's annex provides that decisions of the arbitral panel rendered in accordance with the provisions of this article shall be final and binding. No appeal may be made against arbitration decisions. To me, the provision is clear, but could have been more, if I can say, bulletproof, because the problem here is under Egyptian law, you can only challenge an arbitral award by way of filing a nullity action. And such nullity action is not considered an appeal. So it's considered a separate, unique remedy that is available only to arbitration awards. So when we see that the provision of Article 2.8 of the annex of the treaty's annex, when it says it cannot be appealed, there comes in, there's room for interpretation. Well, and whether or not whether we adopt a wide interpretation or a narrow interpretation, again, at the end of the day, it's left for interpretation of the courts. So in my opinion, and I would love to hear Gaston's thoughts on that, the drafters of the treaty, in my opinion, could have used more elaborate wording that covers all types of appeal and review by any domestic courts. And if they've done that, then we would not be dealing with a situation where a domestic court comes in and say, okay, the treaty prohibits or prevents appeals. The nullity action is not an appeal, therefore I have jurisdiction and power to review the challenge. So the second issue that is relevant here when we look at the treaty is that akin to the Exit Convention, the treaty does not in any way refer to a seat or a place of arbitration. And this brings us again to the idea of delocalization under the Exit Convention and under this treaty in the opinion of some. So if there's no seat of arbitration, then we cannot say that the Egyptian arbitration law applies, even if the parties had agreed to Egypt as the seat of arbitration. And whether or not the parties agreed to Egypt as the seat of arbitration is a question mark, because it's not very clear from the wording of the appeal court's ruling whether or not Cairo was agreed upon as the seat or simply as the venue of the hearings. So that's another issue to think about. So now that we've discussed what international law entails in terms of the provisions of the treaty, we come to Egyptian domestic law. And by that, I refer to the Egyptian Arbitration Law number 27 of the year 1994, as amended several times over the years. So the Egyptian Arbitration Law is based on the UNCITRAL's model law. It applies, or its scope of application extends only to two cases. The first is where the arbitration is seated in Egypt. The second scenario in which the Egyptian arbitration law applies is where we're dealing with an international commercial arbitration that is taking place outside of Egypt, but the parties, the disputing parties, have agreed to apply the Egyptian arbitration law thereto. So these are the two situations where the Egyptian arbitration law comes into play. And it's important, to note here that these two cases or scenarios are not satisfied. And again, we're dealing here with an investment arbitration, not an international commercial arbitration. It took place in Cairo, but it's not clear whether or not the parties have agreed to Cairo as the venue or the seat. So the point of the seat is a gray area. But what we know for sure is that the parties did not agree explicitly on the application of the Egyptian arbitration law to the proceedings. The parties did, in fact, agree to the application of the arbitration rules of the Cairo Regional Center. And when we review these rules, we'll find that we don't really have any provision that talks about, in case of a lack of an agreement between the parties as to the seat, a certain seat, is deemed to have been agreed to, or something like that. So there's nothing actually relevant in the arbitration rules of the Cairo Regional Center that covers this lacuna in the agreement of the parties. So we've seen there is a question mark regarding the admissibility of a nullity action as filed concerning this specific award. The second issue is, if we move past the issue of admissibility and the jurisdiction of Egyptian courts, what is the scope of review and what level of revision can be exercised by Egyptian courts when reviewing arbitration awards? And this question is covered in detail in the Egyptian arbitration law. We have an explicit article 53 of the law, which provides an exhaustive list of cases where an arbitral award can validly be challenged by way of a nullity action. And the first thing to note when we review the provision of Article 53 is that it's only the scope of nullity action as governed and regulated under Egyptian law is limited to issues of procedural irregularities. So in no way whatsoever does the level of review and scope of revision extend to any issues concerning the merits as dealt with and discussed and decided upon by tribunals. So for example, we have in Article 53 as grounds for claiming nullity of an award, the non-existence of an agreement to arbitrate, or if such an agreement existed but is null and void or capable of being nullified or has prescribed with the lapse of its duration. A second case is one where one of the parties to the agreement to arbitrate has concluded the agreement to arbitrate while being incapacitated. And it's interesting to note here that the Egyptian arbitration law refers this matter to the law governing the capacity of the party, of the concerned party. So here again, when we talked in the introduction about how complex the situation can be when we're dealing with international commercial or investment arbitration, we're dealing with parties usually coming from different jurisdictions. And it's very important to note that different laws can come into play. And as we see here, the capacity of a party concluding an arbitration agreement is referred by virtue of an explicit provision to the law governing the capacity of that person. So even if the arbitration proceedings themselves are governed by a certain procedural law, the issues of capacity and the validity and formation of the arbitration agreement itself can be subjected to a different law. So it's very important to be aware of that and to take that into consideration when assessing, whether or not to proceed with arbitration and what are the chances of success of implementing and enforcing a favorable award. And then Article 53 goes on to tackle issues of due process, the exclusion of application by the tribunal of the law applicable to the merits as agreed to by the parties or as decided by the tribunal itself at the beginning stages of the arbitration. So again, all of it is limited to issues of procedural irregularities. Having that in mind, and we go to the Cairo Court of Appeals ruling, we see that the Cairo Court of Appeal decided to nullify the award because of two things. The first thing, the Cairo Court of Appeal criticized the tribunal's award for taking into account the lost profits aspect when calculating the due compensation. So that's one. The second point is that the court criticized the tribunal for basing, for adapting the quantum available to it in expert reports provided by one of the parties during the course of the arbitration proceedings. And these 2 points are, we can look into them and analyze them. So if we start with the first one, the issue of the scope of compensation that is due to the investor. And if we recall, we've said earlier that the applicable law to the merits includes two things: the law agreed upon between the parties, or in case of failure or lack of an agreement by the parties, the tribunal decides which law applies to the merits. And at the same time, we have international law. And it's actually surprising that the Court of Appeal, when criticizing the issue of the scope of compensation, did not really refer to provisions of international law that governs the calculation and scope of compensation in investment arbitration, as established throughout the years by investment tribunals in famous cases. And the court did not, again, refer to any relevant provisions of the applicable law to the merits, which is Libyan law, when determining what the scope of compensation is. We have to say here that the issue of the scope of compensation is a merit-based issue, and thus it could be argued that the court could have or should have referred to the applicable law to the merits, and including international law when criticizing this issue. And again, when we mentioned Article 53 of the Egyptian Arbitration Law, we've seen that the scope of a nullity action does not extend to the merits. I would say the issue of the scope of compensation is related to the merits. And here comes another question mark. The second issue that the court criticized the tribunal or the award for doing is basing the award on expert reports submitted by the claimant, which is the foreign investor. And actually, as a matter of Egyptian law, it is well established that courts and tribunals they enjoy a wide scope of discretion in assessing the evidence put forward before them by the disputing parties. Tribunals and courts under Egyptian law are also empowered to delegate certain matters to an expert, a court or tribunal appointed expert. And as long as the parties are allowed the opportunity to respond, to review expert reports submitted and to comment on them, no arguments of due process can be advanced or can be successful. So as we've seen, it could very well be argued that both points of criticism do not really fall within the scope of nullity action, and therefore leads us to questioning whether or not the ruling of June 2020 signifies some sort of a turn in the tide of scope of review by Egyptian courts of awards, whether in international, commercial, or investment arbitration. And now that we've seen how the court proceeded with analyzing the award and what the reasons for nullifying it are, I think it's prudent to mention a couple of points that can serve as concluding remarks. I think the treaty, the Unified Agreement for the Investment of Arab Capital in Arab States of 1980, could have been more bulletproof in terms of One, the delocalization of the arbitration proceedings that take place pursuant to the treaty, and that's a very important point that could have been, copied from the Exit Convention. Two, the immunity of the explicit immunity of any arbitral award rendered pursuant to the treaty from review by any domestic courts for any reason, except for procedural irregularities. Or the drafters of the treaty could have opted to create a separate body that has jurisdiction to hear or review arbitral awards rendered pursuant to it under certain cases provided in an exhaustive list. And C, three, we have a provision could have been added to the treaty concerning the automatic recognition and enforcement of awards. And this, again, is very important and very beneficial in terms of providing security to parties, when they agree to arbitration, they know that at the end of the day, if they have a favorable award, they can proceed with enforcing it in the jurisdiction of any of the member states, and that the treaty provides for automatic recognition and enforcement. And finally, I would say we need to wait and see, if the Cairo Court of Appeals ruling is, challenged by way of cassation, and what the Court of Cassation might say in relation to the points we raised, or perhaps other points. And again, this ruling of the Cairo Court of Appeal is very important, I would say, to practitioners who handle arbitration and nullity action cases here in Egypt, and to international counsel and interested parties who are involved in arbitration proceedings in Egypt, or are to be involved in the future. I might be a bit early, Gaston, but I don't really like to repeat myself, so I would hand the floor back to you if you have any questions.
Okay, thank you. Thank you, Muhammad, for this very clear statement. And we had only one question, and the question was to know whether there will be a certificate of attendance if the AFA will give that. I think this question can be solved by Madame the Secretary General. And such questions, to my humble opinion, is an evidence that the topic was really interesting, because if something is not interesting, you don't need to look for an evidence that you attend the session, you see. So I'm very thankful for your clear statement. And the case exposed is really very important, to my humble opinion, because you see, we have 3 occasions to come before the Cairo Court of Appeal, you see, and it's only at the 3rd turn that the court decides to annul, you see, or to set aside the award. But the grounds for doing this are not so clear, to my opinion, and I think you also said it, because from what I've heard, the court did not rely on any provision of the treaty. And talking precisely about the treaty, and I share your opinion that it was not so clear, which means that there is a need, to build the capacity of these actors whose duties is to negotiate and sign treaties on behalf of their states. Because a treaty, that is where the the dispute, to my humble opinion, begins. If a treaty or any other agreement is not clear for everybody, this might be the first source of difficulties because it won't be easily implemented. And now, with what we have said, we have an evidence that if the treaty is not very clear, even the arbitral tribunal, you see, might make some error because the treaty was not very clear. And when the Court of Appeal first refused to set aside or even to receive the action, I think there is another problem here. You have cited a provision from the treaty that is Article 28 of the annex of the treaty. Let me say it, and I read it completely. Decisions of the arbitral panel rendered in accordance with the provisions of this article shall be final and binding. No appeal may be made against arbitration decision. So, what do you put in the word appeal? Is it an ordinary appeal or only the grant to set aside an award? To my opinion, this is not the same thing. If you interpret the word of appeal as allowing parties, you see, to challenge the award, it means that the court enjoys the capacity of going into the merit. Whereas we know in general principle that to set aside an award, the grounds are limited, you see, and there is no way for the competent court to go into the merit of the case when it deals only with the nullity of the award. So you are right, I share your position. According to which the treaty was not clear enough. But to my humble opinion, I don't know whether the Court of Cassation, the Supreme Court, can be blamed, because there is a general principle against, if there is no appeal in the common sense against an arbitral award, there are grounds to set aside the award. So the two are not the same thing. But now I think we have two questions, and let me put them to you. The first question from Edouard Luc from Gaborone is, how did the tribunal determine the issue of seat and venue? Can you give some answer or an answer to this, to this question?
Sure, Gaston.
Yeah.
So it's, if I understand correctly, Mr. Luke is asking how the tribunal approached the issue, the arbitral tribunal. Although I have not seen the award rendered by the tribunal itself, but we've seen the Cairo Court of Appeal ruling, and we've seen how it probably quoted or copied and pasted, the agreement of the parties to have the arbitration governed by the arbitration rules of the Cairo Regional Center, and to have the arbitration hearings in the Egyptian capital, Cairo. So in my reading and in my opinion, we have an agreement here between the parties as to the venue, which is the place of any hearings that might take place in the arbitration. And the venue under Egyptian law, and I believe international and other jurisdictions as well, the choice of the venue does not really have any legal effects in terms of the application of any domestic arbitration law. But I would have to say that we would need to see the tribunal's award once made available to us, and see whether or not there was an explicit agreement to a certain seat. So as to the tribunal, it's not clear because the award has not been made publicly available. But as for the Cairo Court of Appeal ruling and how it conveyed the parties' agreement, I think the situation is clear that the parties agreed to Cairo as the venue and not as the seat.
Okay, so there is a second question.
I hope this answers the question.
Yeah, but I know, look, if he's not satisfied, he'll come back to you again. So the second question I can read to you is, what is your opinion of the ruling issued by the Egyptian court in the arbitration case between Libya and Qarafi? Have you got the question?
Yes,
Muhammad.
yes, Gaston, thank you. I think, yes, I think Mr. Hindawi, is referring. Yes, I think Mr. Hindawi is referring to the same ruling that I discussed today with the attendees, the ruling of the 3rd of June 2020. And I believe the comments that we've discussed in terms of the, first of all, the admissibility of the case, of the nullity action, and the scope of review, there are comments to say, and I think, as we've explained earlier, there are comments and arguments to say regarding the jurisdiction of the Cairo Court of Appeal and the admissibility of the nullity action. And there are things to say regarding the scope of review. And it could be argued that the court exceeded the scope of review as outlined and regulated in the Egyptian Arbitration Law.
Thank you for that question. I don't see any other question here, but I personally have a question. Last time, and you have clearly indicated here, that the critical rules of arbitration were chosen by the parties to the treaties as the rule to be applied in the merit of the case. And you have indicated very clearly that there is no provision in these rules concerning the challenge of the award. And I think in that case, you have to refer to the arbitration law of the seat of arbitration. And according to what you have said, if I'm wrong, you might correct me if I'm wrong. According to what you have indicated, Egyptian arbitration law does not allow any challenge against international arbitral award. Is it what you said?
It is, but with a slight qualification. So you can challenge arbitral awards rendered in domestic arbitration, international or international commercial arbitration, but there's a certain exhaustive list of situations where you can do that. And these are all related to procedural irregularities. Nothing merits related can be invoked before the court hearing a nullity action. And I think that that's where, the Egyptian arbitration law was influenced by the UNCITRAL model law.
Yeah. Okay. You have also indicated that the Court of Appeal has issued the third ruling in June, and that there is an appeal against this ruling before the Egyptian Supreme Court. Is it the case?
There might be.
But there is
so
not.
You have. I'm not personally aware of, I cannot say 100% whether or not there is a cassation challenge. But under Egyptian law, you have a period during which you can challenge the appeal court's decision by way of cassation. So I think in the coming months, the imminent become more clear.
Okay, but that said, according to you, what is the influence this ruling can have on Egyptian arbitration? This ruling issued by the Cairo Court of Arbitration, Court of Appeal, concerning this investment
Yes.
non-exceed investment arbitration.
I think if the Cairo Court of Appeals ruling is, become immune from challenge, if the period for challenging it ends without a challenge being filed, or if the Court of Cassation upholds the Court of Appeals ruling, then we would have to say that this ruling would have an adverse reaction or an adverse effect on the future of arbitration in Egypt and the region. And this, I would say, would go back to the keenness of the parties to have an award that they can enforce at the end of the day and get, whatever compensation is awarded. And I would say parties concluding agreements and contracts these days, it would be prudent of them to have a look and to get professional advice regarding the seat of arbitration and the applicable law to the arbitration agreement itself, the proceedings and the merits. And I would say in order for them to be prudent, they would need to consider how the situation is in jurisdictions where the other contracting party has assets, because at the end of the day, when you have an award and you want to enforce it, you would have to look at the country where that party has assets. Having the award recognized and theoretically enforced on paper in a different jurisdiction does not really lead to any practical effects. And in our analysis, I believe we need, as lawyers, advising international clients, we need to be very practical, because at the end of the day, we need to take their business considerations, in mind. We need to keep these in mind and to give them practical advice to ensure that, if they get favorable awards, they can cash it in.
Okay, we still have 2 minutes, and there is one last question from Adole Azu, and the question is as follows: how often do the Egyptian courts get applications challenging arbitration awards? What percentage of arbitration awards are challenged by parties? What is the main reason cited for challenges?
Okay, I'll try to be sure. I'll try to be as brief. Yes. For the first part of the question, I would say it's very frequent that the losing party to an arbitration proceeds with challenging the award by way of nullity action. So it's very frequent, and I would say 98% of the arbitrations we handle as a firm, we automatically know that once we have a favorable award, we wait for that, nullity action writ to be served to our clients, and we prepare for that. As for the second part of the question, I would say, again, the percentage is very high, and the reasons cited for challenges can be classified into, I would say, 2 categories. The first one are the formal grounds. We, in practice, see parties, challenging awards and citing the failure of the tribunal to include certain information in the award itself, and that such information is required by the Egyptian Arbitration Law. So they refer to the lack of including certain necessary information in the award itself. And to be clear, such information relates to details of the parties, details of the arbitrators, the seat of arbitration, copying the text of the arbitration agreement itself in the award or attaching it to the award, and so on and so forth. The second category, and I would say that the most important, are grounds that relate to procedural irregularities, such as not allowing a party to review and comment on certain submissions made by the other party. This is the most frequent one. And we've seen how tribunals are being very, detail-oriented and careful, because I think arbitration practitioners, whether here in Egypt or abroad, are very keen on performing their duty to the best of their abilities and to render an award that is immune from challenge. So I would say from my experience that tribunal members are very keen on avoiding any procedural irregularities in order to render their award immune from challenge.
Okay. With that, I wish to thank Muhammad for the good mastery of his subject. It was very clear and the topic was very interesting. We wish, personally, I would like to be updated on the development of this case eventually before the Egyptian Court of Supreme Court. Now the time is over now. I wish to thank you again for your clear presentation. I wish to thank the attendees for the presence, and we'll be happy to see you in another occasion. Thank you so much, and bye-bye.
Likewise, thank you very much, Gaston. Goodbye.